It must be admitted that after the Restoration, the colonies lost that liberty of commerce with foreign nations they had enjoyed before that time. As it became a fundamental law of the other states of Europe to prohibit all foreign trade with their colonies, England demanded such an exclusive trade with her colonies. This was effected by the Act of 25th, Charles II, and some other subsequent acts, which not only circumscribed the trade of the colonies with foreign nations within very narrow limits, but imposed duties upon several articles of their own manufactory, exported from one colony to another. These acts, which imposed severer restrictions upon the trade of the colonies than were imposed upon the trade of England, deprived the colonies, so far as these restrictions extended, of the privileges of English subjects, and constituted an unnatural difference between men under the same allegiance, born equally free and entitled to the same civil rights. In this light did the people of Virginia view the Act of 25th, Charles II, when they sent agents to the English court to represent against taxes and impositions being laid on the colony by any authority but that of their General Assembly. The right of imposing internal duties upon their trade by authority of Parliament was then disputed, though you say it was never called into question, and the agents sent from Virginia upon this occasion obtained a declaration from Charles II, the 19th of April, 1676, under his privy seal, that impositions or taxes ought not to be laid upon the inhabitants and proprietors of the colony, but by the common consent of the General Assembly, except such impositions as the Parliament should lay on the commodities imported into England from the colony. And he ordered a charter to be made out, and to pass the Great Seal, for securing this right, among others, to the colony. But whether the Act of 25th, Charles II, or any of the other acts have been complained of as infringements of the rights of the colonies or not, is immaterial. For if a man of superior strength takes my coat from me, that cannot give him a right to my cloak, nor am I obliged to submit to be deprived of all my estate, because I may have given up some part of it without complaint. Besides, I have proved irrefragably that the colonies are not represented in Parliament, and consequently, upon your own position, that no new law can bind them that is made without the concurrence of their representatives. And if so, then every act of Parliament that imposes internal taxes upon the colonies is an act of power and not of right. I must speak freely. I am considering a question which affects the rights of above 2 millions of as loyal subjects as belong to the British Crown, and must use terms adequate to the importance of it. I say that power abstracted from right cannot give a just title to dominion. If a man invades my property, he becomes an aggressor, and puts himself into a state of war with me. If I have not strength to repel him, I must submit, but he acquires no right to my estate, which he has usurped. Whenever I recover strength, I may renew my claim, and attempt to regain my possession. If I am never strong enough, my son or his son may, when able, recover the natural right of his ancestor, which has been unjustly taken from him.